2024 and what that means for California employers here in 2025. I'll try to get through this pretty quick. I know a lot of people on the call probably been through this and know it, but it's good for anybody else that is kind of new to California or coming into California is not aware of PAGA and what this means. So this law dates back to 2024. I was just getting out of law school in 2003, and it didn't get a whole lot of attention. It was a law that was just passed by Governor Davis on his way out as Governor Schwarzenegger was taking over. This was one of actually the last bills that he signed, the last laws that he signed as he was leaving office. And it stands for the Private Attorney General's Act. And this was passed because the California Labor Commissioner, the Labor Commissioner is comprised of some different departments. The DIR, Department of Industrial Relations, is part of that as well. So when I say Labor Commissioner, I mean kind of the overall departments that are in charge of enforcing California labor code and labor compliance. But those departments in California just didn't have the resources to keep up with the demand of filing these claims and keep up with labor commissioner claims and enforcing the labor code. And the California Labor Code has certain provisions available to the state that was only available for the state to enforce. So if the employer violated certain provisions, the Labor Code said the state of California could come in and assess these certain penalties and collect and do that. But the state didn't have the resources to go out and enforce that. So that's why PAGA was invented. The state said, look, if we can't enforce this, why don't we privatize this enforcement of the labor code provisions that the state could have recovered, but allow private attorneys to get a client, a worker that's been impacted, and then they can step into the shoes of the state and enforce these civil penalties that the state could collect. And that's how it was developed and implemented. And I'll cover some of the details here. But PAGA said, look, for a private lawyer to step into the shoes of the state, they need to go through some administrative procedures. They need to file a notice with the Labor and Workforce Development Agency, the LWDA, basically a letter to the LWDA saying, hey, we're going to proceed with this lawsuit. Here's some of the allegations that we're going to proceed on. And then if the LWDA doesn't respond and say, hey, we're going to take over that case and just quiet about it, 65 days later, the plaintiff's attorney then can bring this suit. And the plaintiff's attorney had a lot of remedies to recover penalties under PAGA. Basically, under the old PAGA, as long as their plaintiff had one violation, say they had a missed meal break, that they could bring claims to recover penalties on behalf of all employees for the employer for all different types of violations, even if their one plaintiff didn't suffer that violation. So they could bring it on behalf of other employees for expense reimbursement, off the clock work, as long as their plaintiff had one violation. So these cases got really big, really quick. They're not class actions. They're different than class actions, but under California law, it's called a representative action. And because it was a relatively new law in terms of how the legal system works, 2004, the cases were starting to develop how to litigate these cases and what defenses were available to the employer. And unfortunately, as time proceeded, employers were trying to argue a lot of defenses that were applying to class actions in terms of manageability and numerosity, but the California courts were shutting those arguments down. And so these PAGA cases really got a lot of additional, they're starting to be brought a lot more as time came on. One big issue too that resulted in a lot more of these PAGA cases being filed, the US Supreme Court said employers could implement arbitration agreements with class action waivers in them. And those started to be enforced right in 2001, 2002. And that allowed employers to get some protection on the class action front. But then the plaintiffs here in California said, well, PAGA doesn't allow the employee to waive their ability to bring a PAGA lawsuit. And I'm not going to get into the weeds. It went up to the California Supreme Court and then came back to the US Supreme Court and then came back to the California Supreme Court. But basically, California has said no, employees can't waive their ability to bring a PAGA case. You can't have a PAGA waiver, but you could still have a class action waiver. And we'll talk about this, the pros and cons of that, the slide here a little later. But these PAGA cases became super valuable for the plaintiff's bar because you couldn't bring a class action anymore, but you could still bring these PAGA claims. And in this slide, it shows we had a little dip in 2002 when we had the US Supreme Court saying the employees could waive their PAGA claims. But then the California Supreme Court quickly stepped back in 2003, said, no, you can't waive PAGA claims. They could still proceed. So that's why we saw this step up here in 2003. The number of PAGA letters filed with the LWDA has just been increasing. And I just updated this chart here in 2004. We had just over 10,000 PAGA letters filed last year. So as you can see, it's been a record. So even with the PAGA reform, it hasn't led to a drastic decrease in the number of these PAGA cases. And here in this chart, I broke down how many PAGA letters were filed each month in 2004. And you can see we had a little bit of a blip in June of 2004. This is when the reformed PAGA was implemented and passed. And the plaintiff's bar in the news, it got out that there was going to be a potential reform. So the plaintiff's bar thought, hey, if I file these lawsuits now, the old PAGA is going to apply. So that blip was basically people trying to get into the the old PAGA law, filing the old PAGA claims. But as you can see, we had a bit of a decrease then in July and August, but it's ticking back up. And so it's still a major issue for California employers. And with the reform, we're not seeing a huge decrease in the number of these cases filed. So it's something that employers still need to pay attention to. And the reform does open up a lot of new arguments for employers and a lot of protection for employers as well. But they do have to start taking these reasonable steps to comply with the labor code. And we'll walk through what those mean and what that is going forward. So the PAGA reform came through in 2004. It was passed June 17th by two bills, SB 93 and AB 2288. So it applies to all cases filed after June 19th, 2024. So if you have a PAGA case that was filed prior to June 19th of last year, the old laws still apply. And then all cases filed after June 19th, we've got these new PAGA rules. We're going to be focused on the penalty caps and what these reasonable steps are for employers to get the reduced penalty. But there is wide-ranging benefits for employers in terms of litigating these cases too. And we won't cover those today, but opened up a lot of additional defenses for employers, which was huge in defending these types of cases going forward as well. And as I mentioned here, if employers can establish reasonable steps, there's two scenarios they get a penalty reduction. The first one is if before they receive this PAGA notice or a records request by the employee, so a PAGA notice is that letter to the LWDA, which the employer has to be CC'd on. If you've taken reasonable steps before that goes out or you receive that, you've got an argument that PAGA's penalties are capped at 15% of what they could get under the statute. Huge reduction. And then also, even if the employer can't establish reasonable steps prior to the LWDA notice or a records request, they can take steps after receiving that, and then it entitles them to a 30% cap. So there's still something, even after you receive the notice or records request, that the employer can be doing to get a huge benefit on these penalties, reducing the total liability by a huge amount.